Okay, we're live. This is The Secret, How to Fight CPS and Win. I'm attorney Vince Davis, and I'm joined by three special guests this evening. Let's see who we have in the house. We have Miss G, Miss Georgette Truan. Miss Georgette, how are you doing?
Just fabulous, Mr. Davis.
Good, good, good. I could tell in the tone of your voice. Miss Cassandra, how are you doing?
I'm good.
Good, good, good. And thank you for joining. And then we have Miss Julie. Miss Julie, how are you?
I'm okay, Vincent. Thank you for asking. How are you?
Good. So, you and I haven't met or talked before, I don't think. What brings you to the CPS world?
I have an active ACS case in the Bronx County of New York State, and I have watched many of your videos on YouTube. And thank you for giving information to parents fighting CPS, ACS throughout the country. And I had a couple questions that I was wondering if you could help me answer.
Certainly. Before you ask me those questions, can you give us a little background about your story, your case?
So, 4 years ago in 2018, my oldest son's father, he had a substance abuse issue and was physically and verbally abusive. And I finally called the police on him, and he put multiple false allegations against me. Labor Day weekend of 2018, I was bringing my son, who was 2 at the time, to a water park in Manhattan, and I tripped with the stroller and I brought him to the hospital. I was not thinking about that I had an open ACS case. I brought him to the hospital to make sure he didn't have any injuries. He had a little red mark by his head, and he ended up being removed at that point. I did get custody back. His father kept calling on me. I filed police reports, changed my phone number, and then around right after Christmas of 2018, his father had contacted me, and I tried to get him arrested. I tried to have him arrested at the hospital, and they ended up removing my son instead and said that I violated an order of protection when I was the protected party, a family court order of protection that, number one, was not even served by ACS, the petitioner. I had had a criminal court order of protection that I was enforcing, and they charged me with inadequate guardianship. So ever since then, I've been dealing with a lot of judicial misconduct, perjury on case history by the ACS attorneys, and no one was counteracting it. My court-appointed attorney basically just silenced me. It was some Bronx defenders. I talked to the supervisor there. I talked to the commissioner of ACS in Manhattan and the assistant deputy commissioner about these unethical issues that the attorneys were contributing to. And basically, the last 4 years, I've done a lot of research, and in family court, there's really no oversight. And it's one of those things. I've been scared to speak out due to like fear of retaliation, but I'm at the point that I'm not going to suffer in silence. And if I don't be a voice for the voiceless of my children and other children, nothing's going to change. So what are my options? And I don't want my kids to suffer anymore. I just recently gave birth at 43 years old to a beautiful little baby boy, and they want to remand him. I've been pumping my milk for 7 weeks. He, none of my kids should be removed. But it's just egregious that the courts, in my perspective, view children as a paycheck and job security. It's not in their best interest. It's in what's in the best interest monetarily for the court. And I live in Manhattan. My son was born in Manhattan. And my first question is, how can Bronx County have jurisdiction over this case? if this child was born in Manhattan, and that's where I currently reside, and I've been residing here for 2 years.
Well, that's a very good question. If you were, are the Bronx and Manhattan in different counties?
Yes, there's Bronx, Brooklyn, Queens, Staten Island, Manhattan.
Now, those are boroughs, what you guys call boroughs, but are they considered different counties within the state of New York?
There's all different registered family courts. Like the family court in Manhattan is 60 Lafayette Street. The family court in the Bronx is 900 Sheridan Avenue. They're all different counties. It's Bronx County Court. It's Manhattan County Court.
Okay, that's the answer I'm looking for. Now, if you were in California, the court where the child was born and resides would have jurisdiction. So, assuming that New York is like that, and New York and California law are, very similar in a lot of different ways. I don't know if this is one of the ways, but um, you should have your lawyer research that and make a motion. Now, the bad thing that could happen is that they could call up Manhattan County and say, hey, blah, 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 and the Manhattan comes out and detains the child, and then you'd be fighting in two different courtrooms. But they would have the decision on whether they're going to file the case. Has your lawyer made any type of, motion to prevent them from being involved in this child's life?
The attorney that I was appointed back in 2018 basically has been helping silence me and inadequate representation of counsel. I've requested to represent myself as sui juris counsel, which is of sovereignty, which I'm not viewed in the court as a dependent, and they've denied me of that. And when you were stating that, I was just looking for my paperwork. I personally, in September 2nd, when I was in a high risk unit in the hospital because I had postpartum preeclampsia, and then I was further just diagnosed with cardiomyopathy and pulmonary embolisms. So I'm dealing with a lot of health issues, and I think some of it's some stress. But the judge wrote in the remand order, after denying a frivolous challenge to subject matter jurisdiction and a request to change venue, as well as various other applications by respondent, the court found matter of Ballard versus HSBC Bank USA 6 NY 3D 658, 664, 2006, holding a respondent actively participating in the proceeding and party acquiesced to personal jurisdiction and waived defects of the service. And they had in New York, it's called a 1027, which is a remand hearing, and he denied me a 1028, which I believe is I'm not quite sure what you guys call it in California. The 385, I think I've heard on your show, but a 1028 is a request for a immediate hearing for return to custody, and I've been denied that. So that's a denial of my due process. But the jurisdiction, he said it was a frivolous thing, and there's letters here from New York County investigators of ACS investigating. Like, it's New York County investigating. It's not Bronx County investigating. So it is a jurisdictional issue. They have no right to put their hands on my newborn.
Are you representing yourself or no?
I've been attempting to, but the judge also said I was not able to, and he kept the inadequate representation of counsel of the Bronx defenders as a legal advisor over my objection.
Okay, so let me tell you this, and you're not going to like this. Representing yourself is one of the worst strategies you could try to implement. You know why?
Because I'm not taken seriously by the courts.
Well, that's one of the reasons as well. It wasn't one of the reasons I was thinking of. What I was thinking of is that you have no knowledge of the law, the substantive law. You have no knowledge of the evidentiary law. You have no knowledge of the Code of Civil Procedure in your jurisdiction. And although you could Google a lot of stuff, I doubt that you're going to understand the statutes in the case law. It's one of those things that people think they can represent themselves and do a good job. That's a myth. Now, people say, well, I know so and so and he went to court. Will somebody who's in proper ever win in court? Yes. I'd say maybe 1 out of 1,000. That's a very low probability. And we're talking about your children, okay? So we want to take the higher probability road, okay? This case is not about you being right. This case is about you winning and getting your children back. And you being right, that's a totally different thing, okay? And sometimes when people represent themselves, they get caught up in that. It's about them being right and not winning. Okay, so I want you to at least rethink that. Try to get another lawyer. In California, they have something called a Marsden motion where you can make in writing and, you can get a new court-appointed attorney. I think I even have a video on it. But I am almost positive that your jurisdiction has the same type of motion, but it's probably called something else.
But in the Bronx, it's only Bronx defenders. There's no other attorneys. I can't even get an 18B.
There must be more than one law firm under the Bronx Defenders, because if your case had a father and minors, that same law firm couldn't represent all three people. So there's more than one law firm probably under Bronx Defenders. In Los Angeles, this is how they do it. Most of the court-appointed attorneys who represent parents are under something called Los Angeles Dependency Legal Services or something like that. It's LADL for short. But under LADL, there's like 4 or 5 or 6 different law firms. So you could you can get rid of your LADL 1 attorney and be given a LADL 2 attorney or a LADL 3 or 4. So you can always get another attorney if a conflict exists between you and your representation. Now, we haven't talked about the conflict, but it has to be an actual conflict. You just can't say, Judge, I don't like this guy. He's, a knucklehead.
Well, no, back in 2021, 2020, he didn't file. Actually, let me go even further back. 2019, he did not file an appeal for the remand of my son. 2020, he did not file an appeal for the remand of my daughter. And in 2021, that's when I had found 18 USC 241 and 242. And I shared with my attorney on April 7th, 2021, that I found that, and I'm going after ACS because they have put falsified case history.
Okay, hold on. Stop.
The next day in court, ACS admitted to a mistake, which was perjury. And then my attorney filed in the appellate court that same day too. That is collusion and corruption under 18 USC 241, 242.
Okay. So here's some more bad news for you.
That doesn't matter to get my kids back.
Right. And guess what? The statute that you just cited, the United States Code annotated, it doesn't apply to your juvenile case.
It's a civil case to sue them over.
Right. But you don't want to talk about suing them. You haven't even gotten them back yet. And let me tell you something. If you don't get them back, your lawsuit goes from, this big to this big.
Well, I've already won a Supreme Court lawsuit case against them in Manhattan Supreme Court.
What did you win?
It's pennies. He'll get 40 grand when he's 18, but he was bit by the same bug twice in foster care within 3 weeks. And they found them negligent. They found the agency negligent.
So do you have your children back?
No, and the whole thing with that wasn't even an intent to.
But this is what I'm trying to tell you. You're focusing on the wrong thing. Now, here's the most disappointing thing. You've been living this, breathing this, eating, sleeping this for months, for years. And in your mind, you have developed, brain thoughts and synapses in your brain to think about this case in one way or, down this road. And I'm telling you, some guy you just met that you might be wrong and you need to rethink this. Now, I don't know you. You're not hiring me. I'm just giving you advice. And I've only been doing this 35 years.
Only.
So, I had a lady the other day curse me out on the phone. And the reason why she cursed me out is I said, hold on. What you just said is not accurate. I didn't even say you were wrong. I just said, hey, that's not accurate. And she cursed me out. You know what she's told me? She told me all about federal common law and how she was going to use it to get her kids back and wanted me to help her with that. Apparently, she had purchased something on the internet for like $70. A paralegal or some non-lawyer had developed this strategy to get her to win in CPS courts anywhere in the country. Okay? It was a scam. It is a scam. Federal common law has nothing to do with juvenile dependency cases. Nothing. And just like I'm telling you, the statute you cited has nothing to do with you getting your children back. It may have something to do with you bringing a lawsuit later, but if you don't have your kids back, that lawsuit is going to shrink in value tremendously. And by the way, in order to sue CPS, it's a very expensive proposition. Forget about the lawyer's fees, just the cost of doing a lawsuit. You need depositions. They may be $2,500, $3,000 a piece. Might have to take 10 depositions. There's filing fees. There's jury fees. There's expert fees. There's expert deposition fees. A few years ago, I watched a very famous lawyer from California down in San Diego. I watched him do what ended up being a 7-week trial. He was suing DCFS in Los Angeles County. And if I remember correctly, he told me that he spent, I think the number was $250,000 just in costs. No attorney's fees. It just cost that much to take the case to trial.
Mm-hmm.
A lot of people think, hey, I've been screwed by CPS, and snap my fingers, I'm in court and I'm going to get in front of a jury and I'm going to win my money. That's totally false. CPS,
that would be icing on the cake for me down the road.
Yeah.
Like, what my goal is to get custody of my children back and protect them. Like, it has nothing to do with trying to do a lawsuit against them. But when I did find the 18 U.S.C. 241, 242, the next day, the first thing the ACS attorney addressed in court was, Your Honor, I would like to address the mistake I made on a previous petition. Paragraphs 5 and 13 had absolutely nothing to do with Miss Rory's case, and I apologize for the mistake. Now, this is blatant aggravated perjury on case history. And that was last year. I haven't followed through with trying to file anything or whatever, but he acknowledged the mistake, which was perjury on case history on court record. So right there, I'm on judge number 8, by the way, too. They keep swapping them. It just is, it's a nightmare. It's an absolute nightmare. And then I have one other question. I don't know how much more time we have, but so the case started in 2018. In June of 21, we had the fact finding, and they found me neglectful of my son, stating that I was obviously intoxicated that day in 2018, which was not true whatsoever. They used past medical history, and it was a judicial error. And then the judge never filed the fact finding in the record room. 2.5 months later, there was a motion for summary judgment for my daughter to be derivatively neglected, and she was born in 2020. This case started in 2018. And just last week, ACS said they wanted to file a motion for summary judgment for my newborn, who was born in 2022. How can my daughter, born in 2020, and my newborn, born in 2022, be neglected from something from 2018?
Well, what they probably are doing is saying the past is a good indicator of the future, because the way the laws are written, at least in California, is that you come under their jurisdiction if you abuse the child, or, and this is the part people don't realize, or if there is a risk that you're going to abuse the child or neglect the child. So they may be using what happened 3 years ago or 4 years ago as a risk, an indicator of a risk. That doesn't mean it's true. They still have to prove it. But that's how they do that. Now,
With the crystal ball theory.
right. Julie, I didn't write the laws. I'm just the messenger.
No, I understand. I totally understand.
So can I be frank with you?
Yes, Vincent, you can be frank
Okay.
if you want.
You have to focus on getting your children back.
Mhm.
Don't focus on what they've done wrong.
I've been trying
Because
to focus on like
even if it is wrong, they're never going to admit it, and it's not going to help you get your children back. You got to come up with a strategy, a plan, and implement it. That means witnesses get on the stand and they can testify, talk. That means cross-examining their witnesses. That means bringing forth documentary evidence, subpoenaing documents to court to show the judge that they're wrong and you're right.
I mean, I have over 120 toxicologies that are all negative. There's never been one that's positive. I have given birth to 2 children, unplanned, but they're miracles from God, at 41 and 43 the past 2 years during COVID and the lockdown. And they're trying to say that no circumstances have changed. Neither of my children, the newborn, the 2-year-old and the newborn, were diagnosed with any type of fetal alcohol syndrome or tested positive for any substances. So how can they say an alleged supposedly neglect charge of alcohol, and then these 2 children are like, there's nothing. Like I know what it's about. It's about the Title 40 funding, but I just am so I'm devastated, and it's in family court. There's no oversight. That's the hard part.
Well, there is. It's called appeals. Have you appealed anything?
I've attempted to, but my attorney blocked me, and he's still listed on the case as the counsel.
Are you able to hire a private attorney?
I don't have 7,500 for a retainer, no.
Because that's one of the things you should call around in your area and find somebody that is cheaper than the $7,500, because you need a private attorney or a new public defender who's going to work with you. Let's quit talking about what they've done wrong or how they can do it or what they did. Let's figure out how to beat the allegations, how to win at the next trial.
How to prove that I'm not a danger to my children,
Right.
and make sure that the judge acknowledges that. But the judge will disable my microphone or silence me in court.
Well, there's procedures. There's a way to do that. There's a way to make a record if the judge stops you or tries to stop you from testifying. But what you got to do is come up with a witness list, come up with an exhibit list, and maybe even a trial brief that all can be all filed with the court. Okay?
All right.
Does that make sense? We have to figure out what to put in the pot to win.
To get on record.
Right. Evidence.
Mm-hmm.
I tell that to people all the time, different shows, I say that. And I don't think anybody's listening to me.
I've listened for a couple of years. George, I could vouch for it.
People ask me, hey, how do you beat CPS? Evidence. What's evidence? People that get on the stand and testify, cross-examination of their witnesses, and documents to prove that you're right and they're wrong. That's it. That's it. It's as simple as that. But everybody wants to argue with me about what the law says, what they think the law says. That's not going to win you your case. You know, many years ago, maybe 20 years ago, 25 years ago, I took a course. And the name of the course, it was like a week long, and it was given by a trial advocacy group. And at this week-long course, they taught you how to do trials the right way. And I had one of my professors in that course was a very experienced law lawyer and former law professor. And, you know, at that time, he had been a lawyer like 35 years. And he said something very interesting that never had dawned on me in 10 years of practicing law. He said, don't try to convince the judge what the law is. It's a waste of your time. Most times, the judge already knows the law, or
Should.
he or she thinks they do know the law. Now, and they asked me, or they told me to focus this way on every case. Every case. Number one, the number one thing you have to focus on is the story and the facts of your case. That's the number one thing. You want to win a case? Story and facts. How do you tell stories and facts? Witnesses and documents.
Affidavits.
Okay. The number two thing you have to focus on, if the story and facts are against you, are the equities, the fairness of different issues and things. So the number one thing is story and facts. If you don't have the story and facts for you, you got to go to the equities. Got to argue the equities. The number three thing, if you don't have the story and the facts for you or the equities for you, the number three thing you have to focus on is the law. Out of those three things, the law is the least important. Is that surprising to you?
No, not from what I've lived through.
Yeah. The law is the least important thing because, you know, what I think the law is, what you think the law is, what Cassandra thinks the law is, what Miss G thinks the law is, it's going to be all different.
Yeah.
But you know what will compel a judge? The facts, the story, and the equities. Don't focus on the law. I should do a videotape about this. I don't think I've ever talked about this before.
Well, I'll tell you something regarding the facts and equities. August 22nd, I was served with an order to show cause for a medical override for my daughter. ACS and the foster agency were alleging that I did not have my daughter vaccinated on January 22nd, 2021 and February 12th, 2021. She was at the pediatrician. She got vaccinated both dates. That week, I gathered the pediatrician records, the state medical vaccine record. You cannot manipulate that. And that Friday is when my newborn son was like, I want out of your body, mommy, because I was so stressed out. And I gave birth to my son on the 26th. However, we had court last week to address that motion that the judge signed off on. And I had the evidence of the pediatrician records and the medical records from the state of New York. And ACS all of a sudden changed their tune, saying that, oh, she's behind on 3 different vaccines right now, and 2 2Ts and 1 18-month. However, the ACS lawyer wrote an affirmation, and the caseworker from the foster agency sign an affidavit, both under penalty of perjury, accusing me of not having my daughter vaccinated in 2021. The judge just totally dismissed that initial order to show cause, the motion that he signed off on. And it's like they changed their narrative in the middle of court. So the facts don't really mean anything, in my opinion, when you have corrupt judges that just cover up and do whatever. Like I literally have all this documentation and a state vaccine record. You can manipulate if you want to try, but it's on record. It's there. Like I can't fake it. She was vaccinated in 2021, and they were trying to accuse me of not doing that. And then they just changed their tune
Hey,
in the
Julie,
middle of court.
let me tell you a story. This probably happened 15 years ago. On a Saturday, on Saturdays, I usually was in my office working every Saturday. And one Saturday, a guy came in without an appointment, and he wanted to see me. So I agreed to meet with him. And he said, "Mr. Davis, I want to tell you a story of a corrupt judge." And he said, "I went to court yesterday, Friday, and I lost my case. And the reason is because the judge totally ignored all the medical records and school records that I had. Wouldn't look at them. And therefore I lost custody of my child." And he said, "I'd like you to change that. Go back to court and change that." I said, "Well, hold on a second. You had all the records from the school and the hospital, and the judge wouldn't look at them?" He said, "Yeah, judge wouldn't see them." I said, "Well, how did you have them? I mean, where did you get them from?" He says, "Well, I just made copies and I brought them to court." I said, "Oh, problem number one. You didn't lay the proper evidentiary foundation to get those documents into evidence. As far as the judge was concerned, those documents are hearsay, and he shouldn't look at your documents." And he said, "Come on, Mr. Davis, everybody knows these are the real records." I said, "You know, everybody else doesn't know. What if you whited out a line and changed something in one of those reports? Who would know that?" And I gave him some more examples, and finally he said to me, he said, "Well, this is an unfair system." He says, "I didn't know those rules." And I remembered something that I heard in law school. It took me many years to even accept this. But did you know in English common law, which is our system, that ignorance is no excuse?
Oh yeah.
So,
Oh.
you might have documents, but if they're not properly authenticated with the right foundation, nobody has to take a look at those.
If you don't swear under penalty of perjury and reply to the motion or whatever with exhibits and
No,
so forth the
no,
proper way.
no. See, your documents won't be looked at. Here's how you get a document into evidence. Number one, all parties must orally or in writing stipulate that's a true and correct copy of the document. Do you ever get that from somebody, from the other attorneys? Rarely. I shouldn't say rarely. I've seen, it depends on what the document is. In LA County, a lot of times, social worker attorneys will agree that, yeah, that's your parenting certificate. But if it's anything really important, like a doctor's letter or a psychiatrist's letter, they probably won't agree to it being admitted into evidence. The second way you can get a document into evidence is you have the person who prepared the document in court on the witness stand to swear that that copy is a true and correct copy of the report that they made. That means you got to subpoena in the person. You ever seen that done? Rarely. Number three, you subpoena in the custodian of records of that business who will come in, who will bring the document in and say, these documents are maintained under regular business procedures, blah, 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 And that copy is a true and correct copy of the record that's maintained in my business or in our business. When's the last time you seen that happen? And let me ask you something. Did you do anything like that in your case, representing yourself? I can bet $1 right now that you didn't. Why? Because you don't know how you get a document into evidence. I might as well ask you to do open heart surgery. They might as well ask me to change the transmission in my car. I can't do it. I don't have the knowledge, experience, tools, supplies, whatever, parts. I can't do it. I'm a fairly bright guy. I don't do auto mechanics. I don't do open heart surgery either. Doesn't mean I'm dumb. Just means I'm not familiar with it. So if you that's why I told you about the bad strategy. You think you have everything lined up, and you probably do, except for you didn't know the ins and outs of evidence. And then you leave court just like that guy left court and says, I got a corrupt judge. The judge wasn't corrupt. Judge did exactly what he was supposed to do. You just didn't know the rules. And since, unfortunately, the rule is ignorance of the law is no excuse, you're screwed. Because you went to court thinking that justice would be done. Your sense of justice. And if you watched any of my videos, I have a couple videos on this. What is justice? It's not what you think it is. And you leave court, and I hear so many people leave and complain about corrupt this, corrupt that. Do I think there's ever any corruption in court? Yeah, I do. But not like people are talking about. Oh, the judge wouldn't see my evidence. Did you lay a proper foundation to authenticate it? What's that? Okay, that answers that question. That's why I say you got to find a lawyer you can work with. Because there's just so many things out there that you're not aware of. And look, you're in the fight of your life. This is the most important case you'll probably ever have in your life. Getting your kids. You should have some legal assistance that is experienced and competent. Don't try to Google this stuff. You'll never fit the pieces together unless you've been to law school. So, call around. There used to be a woman who was a host. She was one of the original hosts of one of our shows called CPS, The Horror Stories. And she made over 50 calls.
Oh, the one out in Virginia.
Before she found an attorney that could help her at her price. By the way, her price was $0. She couldn't afford anything. You got to make those calls. You got to find somebody that's going to work with you and help you. The person's out there. You just haven't connected with them yet. Please don't try to do this yourself. Because you're always going to think, oh, they're corrupt. And sometimes the solution is you just didn't know. So get an attorney, find an attorney, make those phone calls. Because you should not be doing this by yourself. You should not be representing yourself. If I were a doctor and I said, hey, we looked at your test, Julie, and, you need open heart surgery. Get 95% blockage. And number 1 and number 2. Are you going to go out and Google how to give yourself open heart surgery?
No.
Right. You laughed. Right. Exactly. That's what I think when people tell me, oh, I'm going to represent myself.
No, and I've been dealing with very similar medical issue with my heart and my lungs just recently, the past 2 weeks. It's unfamiliar territory to me. Just like some of the law stuff, but at the same point in time.
But You, with the medical stuff, you got a doctor, right? You go see a doctor, right? Same thing for law. You got to go talk to a lawyer that he or she can help you. Don't try to Google this and figure it out yourself. Please, it's going to be a bad strategy. It's not going to end well.
One other thing I want to mention. So when we had the court hearing on September 2nd, I requested to the judge to have unlimited access to my newborn in the NICU to be able to breastfeed, and he granted that.
Mhm.
So from September 2nd till now has been like, what, 6 weeks or so. And so if I'm a danger to my son, I'm a danger to my son, right? Why am I granted unlimited access and I can go and breastfeed and be there around the clock? The NICU is 24/7 at Columbia Presbyterian, and but yet it's a danger for him to come home to me. I can't wrap my head around that.
I didn't hear that last part. What did you say?
I said I can't wrap my head around the fact that it's supposed to be a danger for my son to come home to me, but yet I have unlimited access to him when he's in the NICU because I requested it and it was granted. And for the past 6 weeks, I've been pumping and I've been going and breastfeeding and there whenever I want. And I can't wrap my head around how I'm in danger at home, but not anywhere in the NICU. I can't wrap my head around it.
You know, I understand. No, I don't understand because I've never gone through this. I've heard a lot of people, clients tell me this. Same thing that you're telling me. And I try to drag them over here and help me focus on getting the kids back, not wrapping your head around it. That's what we need to focus on.
Well, my focus has been on providing breast milk and being there and nurturing him and everything. And wouldn't the courts see that, like, with all the efforts that I'm putting in? And I mean, it's my child. I'm going to do that. That's my job as a mother. I took on this role willingly and I want to be a mother. Um, how can they not even acknowledge any of that and just say that I'm a danger on past allegations? It's just I I can't make it make sense.
Okay.
And I don't know how the courts could not see that I'm doing my part and I'm there and I want to be there and I'm not a danger. It's just like they have this pre-existing um, judgment, and nothing I can do can change it.
Well, if I told you, hey, I have $10 million for you right now, if you come up with a plan by Monday about how to get your kids back, would you do something different?
I don't know what I would do different.
Would you?
Like,
You want the $10 million?
no, I want my kids.
That's worth more than 10 million, right?
They're priceless.
Right. So you better do something different. You better come up with a plan after you talk to a lawyer. You know, I've represented many, many, many people. And, am I always right? No. But I get a sense that you should have your children. You're just focused on the wrong thing. And no matter what, it's going to be difficult because it's been so much time you're focusing this way and you should be going this way. I got to get you on the right thought pattern. I need you to think about these cases the right way. Forget about wrapping your head around it. It doesn't make sense. I'm going to tell you right now that the laws that we have, in my humble opinion, don't make sense. So why are you going to try to figure it out? You'll never figure it out. You'll never figure out why people do things a certain way. You know, people tell me all the time, "Oh, Mr. Davis, blah, blah, blah." They have no idea what I'm thinking. But they try to convince themselves that they can read my mind, which they can't. I can't read your mind. I can't read Miss G's mind. Well, that's not true. I can, but I can't read Miss Cassandra's mind, right? You're not going to read the judge's mind. You're not going to read these social workers' mind. Don't worry about things you can't control. Worry about what you can do to win this case. Worry about what you can do to win this case. Okay, and you know what? Since you've been so nice to be a guest on our show, Julie, and share your story, I want you to call Miss G later today or tomorrow and make an appointment. I'd love to speak to you to give you some more pointers about winning this case and about what you can do. And maybe I can make a call and see if I know anybody in the New York area that might be able to assist you on, as a lawyer.
I would greatly appreciate that, and I'll get in touch with Georgette. Absolutely. What I'm thinking, and you tell me if I'm wrong, flood them with positive and documented, like there's no concerns about my parenting, but just flood them with positive stuff like that, and show how I am there and on top of my children's well-being, and that is the most important thing for me, like the schooling and the medical and extracurriculars and so forth for all my children.
That's part of it. There's another big part of this that I want to talk to you about privately. Okay. So call Georgette and she'll arrange it for you. Okay.
Thank you so much for your time and all the information that you've given today and previously and everything. I greatly, greatly appreciate it.
Well, Julie, thank you very much for appearing, and we'll be talking soon.
Okay.
All right. Okay, ladies, before we go this evening, I promised yesterday to talk about the disposition court hearings, which is usually done with the jurisdictional hearing. Sometimes it's done separately. The dispositional court hearing is the most important hearing in all of CPS cases. The most. Now, in California, the social worker has to prove by clear and convincing evidence that you are a substantial danger to the child, and prove by clear and convincing evidence there's no other alternative but to take the child away from you or to place the child out of your care. Now, as far as I'm concerned, that's a big deal for the social worker to prove. It's a huge thing to prove. I'm not saying the social worker has to prove that you're a detriment to the child. I'm not saying the social worker has to prove that you're a danger to the child. The social worker has to prove that you're a substantial danger. And to be a substantial danger, you have to be one bad MF. Now, most of the people that I come in contact, they're not substantial dangers to their children. They're not. It's a hard thing to prove. Now, if you don't have a trial, present evidence on your behalf, cross-examine the social worker, you get to lose that automatically. You just lose. So I'm going to tell you some things that I do in cases in dispositional cases in trial. The first thing I do if I represent a parent is I put the social worker on the stand to be cross-examined. And I ask questions. And in the past, I asked this question or something like this: is my client a risk or a danger to the children? If the social worker says no or a risk, I don't ask a lot of other questions because she didn't say my client was a danger. Sometimes I'll ask the social worker, is my client a substantial danger to these children? Uh, Danger? Not really. Oh, okay, thank you. No further questions. Why do I say no further questions? Well, she just said that my client's not a substantial danger, and I just told you she has to prove that. No need in asking one too many questions. The other thing that I ask social workers is, if they say yes, your client's a danger to the child, I say, oh, okay. I tear off a piece of paper. Judge, may I approach the witness? I hand the witness a pen and a piece of paper. And I say, why don't you give me your top 10 reasons why my client is a substantial danger to the child? First of all, do you know how hard it is to come up with reasons while you're sitting on the witness stand? Secondly, when the social worker writes down her reasons, they're usually bullshit reasons because they've never even thought of that question. In my whole time as a lawyer, I've had one social worker, one, who actually wrote down legitimate reasons. And I've cross-examined a whole lot of social workers. And usually when they write down the list, I say, Your Honor, may I see that list? They give it back to me. I say, okay, here, you write number 1. You wrote blah, blah, blah. Tell me all the facts that support that conclusion. And generally I get this. Oh, you don't have any facts? All right. Number 2, you wrote blah, blah, blah. Tell me all the reasons why that makes my client a substantial danger. And then, it's usually some bullshit they come up with. And I go right down the row. And there's something in cross-examination called drilling down into the answers. So no matter what they say, you say why. What facts do you have to support that? You really cross-examine them. I should become a Amazon affiliate because I'm going to suggest a book for all of you to get and to read. And it's a book called by Posner and Dodd, D-O-D-D. And it's called Cross-Examination Techniques. Books about this thick. They also have a video version that I highly recommend. But if you're going to try to represent yourself or give your attorney some pointers, read that book. Order the DVD. It's kind of expensive. I mean, the course I think is maybe $4.99, something like that. But that's how you cross-examine a social worker to prove that she doesn't have or he doesn't have evidence to support that you're a substantial danger by clear and convincing evidence, not preponderance. And here is something I want to tell you. I was doing a trial once using this very technique, and we got into an argument in front of the judge about whether the standard was clear and convincing evidence or a preponderance of evidence. And the county counsel, the social worker's attorney, was arguing to the judge that the standard of that proof was preponderance of evidence. And I'm thinking, she must be joking. It's clear in the statute. What I realized through the back and forth is that this attorney had been arguing a preponderance of evidence for probably a year in front of the judge. And I'm going to guess that the judge was going along with it. The judge decided to stop the trial, pulled out the law book and went back into the judge's chambers to read what the law is. I'm kind of shocked because I thought everyone knew this. Judge comes back, gets back on the bench and says, Mr. Davis is correct. It's clear and convincing evidence. Now, the prosecutor that I was going against happened to be an experienced social worker's attorney. And I couldn't tell if she just was mistaken or if she was trying to argue something knowing that she was wrong. I don't know. I won the hearing because the judge said that the social worker didn't have clear and convincing evidence that my client was a substantial danger. Like I said, to be by clear and convincing evidence, you're a substantial danger to a child, you have to be a monster. Most people you meet, no matter what they did or what they said, and this isn't all the time, but, they're not monsters. If they did anything at all, they made a stupid mistake. Right? But here's the second part of that. They have to prove that. Then they have to prove there's no less restrictive alternatives. Do you know that most social workers don't consider that at all? I just did a trial a few weeks ago where I asked the social worker at the disposition hearing, what alternatives did you consider to, placing the child in foster care? The social worker's response was, what are you talking about alternatives? I said, oh, you didn't think of anything else? She said, no. She hadn't considered any other alternatives. So how, by definition, is she going to prove that there are no less restrictive alternatives? No one said anything, but I got the impression that most people in the courtroom were surprised that that was even the law. Nobody said anything to me. I was just, the impression I got from the looks from people. So those are the things that I have to say about the disposition hearing. And if you lose your disposition hearing and you think you should have won, you and your attorney should talk and you should file a notice of appeal before you leave the courthouse that day. Don't wait to call the attorney and say, hey, did you file my notice of appeal? You and that attorney, him or her, go to the clerk's office, get the blank form, and file the notice of appeal. It's all taken care of. If you can't afford a private appellate lawyer, the court, at least in California, will appoint you an appellate lawyer. I think you have to qualify, fill out some financial statements and stuff, but well worth it to protect your rights. Okay? All right, so that's all I have to say about disposition hearings this evening. Tomorrow's what, Wednesday or Tuesday?
Tuesday.
Tuesday. I'm losing track of time. Tomorrow's Tuesday. What we're going to talk about is in California known as the first 6-month review. It's the 366.21E hearing. Assuming your child has been taken out of your custody at the disposition hearing, I'm going to tell you what you need to do to win a 21E hearing, the first 6-month appearance. Okay? Now, before we sign off, Miss G, did you have any questions or comments?
No.
All right. Miss Cassandra, did you have any questions or comments?
Actually, I did.
Wow.
I had a question. Can caseworkers make decisions out of court without the judge knowing?
The answer is yes, but it depends. On a spectrum, what kind of decision? Judges always make the final decision.
Like where the children are placed.
Yeah, it depends on the judge's order. At the disposition hearing, usually the judge gives the social worker the right to place the child in any approved CPS home, right? It's just a general kind of placement. If you as a parent want the kid placed someplace else, other than what the social workers decide, you can file a 388 to get a specific placement, generally with a relative or a family friend in Nephrom.
Okay.
All right. So, and anything a social worker does can be reviewed by way of getting a motion or a 388 petition in front of the judge. Anything. Remember what I say. If the social worker does something that you don't like, unless you challenge it in front of the judge, it becomes the law of the case. Social workers don't make decisions. They make recommendations. And if they decide something that you don't like, take it to the judge. He or she has the power to agree or disagree with the, social worker. Okay?
Not true, but okay.
Oh, did Attorney Georgette Truan say something?
Well, it's not true. Social workers are the ones wearing the black robes. They're the ones who make the decision. The judges always follow the recommendation of the social worker.
I'll tell you, in 35 years of doing thousands of cases, that's an incorrect statement.
Maybe because you handled them? Sorry.
How
When the
many
court appointed attorney is handling the case,
cases?
I apologize, Mr. Davis. When a court
Just tell me something. How many cases have you done? Hey, Cassandra, when you're the host, you can just mute.
you cannot do that.
Watch this, Cassandra. Oh, okay.
When the court appointed attorney makes
Anyway, so thank you everyone for listening, and we'll see everyone tomorrow at 7. We'll be talking about the 366.21 hearing, 2-1 hearing, and we will talk about that tomorrow. All right, tomorrow at 7 p.m. Thank you everyone for watching. We'll see you later. Good night.